and is by the civic organizations. Respondents respectfully pray that this honorable court dismiss the appeal in its entirety to lack of merit, find that NIIMS does not violate Article 31, which guarantees the right of privacy, and does not discriminate under Article 27 of the Constitution. We also affirm that the Court of Appeal's decision upholding NIIMS as lawful and necessary governance as a tool. Reaffirm the importance of a secure and integrated identity management system for national development and public service efficiency. My ladies, I'd like to cede the floor to the bench for further direction.
Kindly have a seat, counsel. Applicants rebuttal.
Okay, we had 3 minutes for rebuttals, so may it please the court. My ladies, the respondent averred that English and Kiswahili is the national language of Kenya, and they put reliance on Article 7. I'd like to put reliance on Article 56 of the Constitution, which explicitly mandates affirmative action for marginalized communities. Another thing, in my Constitutional Law 111, Professor Ojuang said that even in case of national importance, due process can never be sidestepped. I like to direct you to paragraph 9 of the fact sheet, where the dissenting judge argued that the procedural irregularities invalidates the entire amendments. So, lastly, I like to the respondent averred that omnibus bill are a form of are not unconstitutional per se. I like to put reliance on paragraph 4 of the fact sheet, whereby inclusion of substantive amendments in an omnibus bill amends parliamentary scrutiny. Those are our rebuttals as the applicants. Thank you.
Respondents, do you have some rebuttals?
My ladies, we'd like to submit that the petitioners have stated that NIIMS implementation should be declared unconstitutional, but my ladies would like to counter that by saying that proper regulation, and as I stated before, proper regulation should be upheld and not invalidation. Just because it poses hypothetical risk as they state does not mean it is unconstitutional. That's our submission.
We have come to the end of this session, and it's been amazing. Allow me to, we're going to give comments before you leave, and we'll be starting from my co-judge from the rights.
Good afternoon. Okay, I think your name is Melanie. Is it Melanie? Yeah. For Melanie, the only issue I had with you was reading a lot. You're reading, you're rapping. I don't know if you're tensed. You're tensed? Yeah, it's okay. It's understandable. Your court demeanor. Yeah, work on your court demeanor. And I also like your composure. You're tensed, but when you're being asked questions, you're not shaken by them. So I really liked that. For Wamalwa, where's Wamalwa? Okay. Wamalwa, I like your court demeanor. I liked your presentation. My issue with you was stuttering and calling us SARS. SARS? We are not SARS. Yeah. I had no issues with you. For Charlene, I couldn't hear you. So I don't know if it was tension. I know your voice can go higher than that. Personal opinion. You kept on saying I. And for all of you, for this side, for the applicants more so, I really like you guys if you could know your case facts. I feel like you guys don't know your case facts. Know your case facts. For Brian, I liked your structure. I felt like in the whole group, you're the only one who had a structure in your arguments. You're thrown off. You're left without an argument. I don't know, you should work on that. Your demeanor, yeah. The applicants, I really have an issue with the demeanor. Yeah, that's the only thing I have when it comes to you. Yeah, that's only, and you have good composure. I like your composure. Yeah, for the respondent side, for Blessing, I liked your intro. You have good composure. Your eye contact and your audibility was nice. You answered questions well, but kuna mali they threw you off kidogo. Yeah, and stop seeking validity. Trust in yourself. If you're saying something, trust in yourself. Don't seek validity. And also like your confidence. For Nyaragi, I liked your structure. I liked your confidence. Don't come at me. You know I'm a judge. Don't come at me. Persuade me. The thing is you persuade me. Don't come at me. If you come all defensive, tapelekana, you know? Yeah. I like your audibility. I had no issues with this side when you came. Okay, demeanor. You guys work on your demeanor, but I liked your presentation. That's all.
Okay, so I'll also start from that end. Melanie, as my co-judge stated, eye contact is very important. If you are trying to persuade someone to find favor in your submissions, you have to make eye contact with them, reduce the amount of reading. Also, presentation of the facts of the case is very important. We kept on telling the team to guide us to the facts. What paragraph of facts are you reading? It is important that as you say the legislations, you are also stating, move with me to paragraph sheet, where we see that this and this. There you can present your most favorable facts, because I saw that the respondents really used that to their advantage, because they saw that you're not saying the facts, they came with the facts, and they were stating them, move with me to paragraph this. Sometimes the opponent can use that against you. Locus standi, Article 22. Whenever you're going to ever say matters of locus standi, as long as you've mentioned Article 22, then the judges will be satisfied. That one has to be said. You left without ceding the floor. You just left. You gave your conclusion and left. You have to say, I cede the floor to my co-counsel, or I cede the floor back to the bench if you are the last counsel. Then when you're giving the facts of a case, this applies to everyone. When you're giving the facts, when you're relying on a case, you have to give citation properly. Are you persuasively relying upon this case, or are you using it bindingly? Of course, there's no case that binds the Supreme Court, but if you're using lower courts and you're using, for example, a case of the Supreme Court on the High Court, then you have to say, I'm using the case of this and this before the Court of Appeal, whose decision is binding before this case. When you are citing a case, it is very prudent for you to give us the facts of that case and then marry those facts with the current facts. I saw Blessings actually did that for certain cases like Katiba Institute. Yeah, to draw similarity from that case and our case, it makes your argument more persuasive. Then Wamalwa, there was the stuttering that she's saying, the use of fillers. When you are finding it hard to say whatever you are saying, it is normal that you will utahang. So you have to use pauses instead of fillers. Whenever you are about to say, just keep quiet. You just pause. We don't know that there's no pause there. So I would recommend you use a pause instead of filler words. Then welcoming questions. If you are asked a question by the judge, you have to say, thank you very much for that question, my lady. Much obliged for that question. It boosts engagement between you and the judges. And that is very, very important. I felt like you had the answers. Your submissions were very nice. Even when I was asking questions to
the respondents, I used your submissions, but you did not put up a fight. I asked you one question and you yielded. I didn't even know how to react to the yielding because I still had many questions. You have to learn how to fight. You had the answers. You just felt like, I don't know that, try. Your co-counsel, Shali was fighting. Her only loophole was she did not have laws to back her up, but she was fighting. Whatever she was saying was making sense. In fact, those were the right answers. She just didn't have the law. You have to learn how to fight. You have the answers there. Every question in tumeuliza, you have the answer. You've read the fact pattern. You know the facts. You know a bit of law. That is enough. You cannot just concede. Ukiona mmepigana sana, that's when you concede and say, I stand to be guided. It is not a must that you know everything. You have to, asking for time, you just stated, give me 1 minute. We say, seeing that my time is much spent, I would like to seek the court to add me 1 discretionary minute. That's how we ask for time. We don't just say, give me 1 minute. I gave you, but that's how we appropriately ask for time. You had very good prayers. Those were very specific remedies that you were seeking. I liked that. Shali, you put up a very good fight. You were speaking at a very low tone. I want to agree with Nerea that you can speak louder than that. That is not. When you meet those people there, they are fighting. People are shouting in your face. You cannot go there and, my name is Shali. No, it is a fight. It's a war. This is litigation. If it's mediation, you can beg them. But litigation is war. So you put up a very good fight. I like that. The issue was you have to back it up with your law. There's no such thing as, it is my opinion. This is not a court of opinion. You have to persuade us with the law or the facts, those two things. Then you guessed the remedies. I don't even know what mandamus is, but remedies. We don't guess. Just say, on matters violation, we plea with this court to declare that the right to privacy has been violated. If you don't have a specific remedy, don't guess, order of mandamus. Then I move to this side. No, Brian, yes. You said, I will, there was some point when you're submitting, I felt like you're giving your submission as opposed to the team's submission. Especially when you were giving the structure, you're saying, I don't know, there was just individuality in your submission. Nevertheless, you were the only person with good structure, very good structure. I was not getting lost. I knew where we are going. Tumetoka wapi, tukienda wapi. When you're asked a question, you go to that question. Wamalo almost struggled with that because he was like, I'm about to say, but he went straight there. We did not, you cannot correct the judge. If the judge wants that, that is what the judge wants. Yes. So you have to go straight to that. Good citation of cases. We struggle with this even with people who have gone through internal rounds. They don't know how to cite a case. You cited your cases very properly. I really liked the way you cited mpaka case numbers. Mpaka ilikuwa imebaki judges. Very good citation. Too much handwork. You are doing this. Why? Who are you fighting? This too much attention. I didn't even listen to what you were saying. I was like, the hands. Yeah. Then print the moot question. In future, kindly print the moot question. When you come with your electronics there, it kind of paints a different picture. Yeah. Never give up. I really didn't like that you and Wamalu were not fighting with us. We ask many questions when you're making sense. Yeah. We ask many questions when you're making sense. You cannot give up at that point. You still had so many things to say. Yeah. Don't add to the facts. There was no point of, what was he relying on? The vetting. There was no vetting. You cannot add to the facts. Unless you have some article written somewhere that shows this process is married with, then that is adding to the facts. Blessing Mugo, what a powerful introduction. I was very, very impressed by your introduction. We were smiling. I don't know if it's because my judges have always taught me to say jurisdiction is everything. That one won me over. Anytime you appear before the Supreme Court, High Court, Court of Appeal, jurisdiction is everything. I wrote good intro, then I wrote wonderful intro. I don't know. I think I was so impressed. Good invitation of questions. You are very responsive when we're asking a question. Thank you. Obliged with practice, but use of cases. When she was citing a case, she was telling me some brief facts, and then to this case, the way you are using cases. When she's rebutting whatever the petitioners had stated, she stated the petitioners have relied upon the case of this. Nevertheless, we seek to draw contrast. She even drew contrast between that case and our case. And hence, the petitioner's submissions cannot stand because the facts of that case and this one are not similar. That was very, very well done. You're giving good answers, but they were very shallow. You're telling me, like you're saying, it's not that. Then you have to build it up. Have a more conversational tone when you're submitting. Learn to practice answers. Whenever you are practicing, you have to ask yourself the questions that you ask. Is the right to privacy absolute? No. The right to privacy is not absolute. We do take note of that. It is subject to limitation. For the applicants, nevertheless, it is a submission. You practice. Know that you are panicked. Blessing. By your introduction, I was like, it's about to kill it. Like, compose myself. She's breathing heavily. She's about to die there. I even asked Zarina, and I was like, take 20 seconds, please. We don't know. You came here in panic. Don't know. Now if I've already given you to be rubbing again and remove marks for composure, I work very hard. Then good stating of the facts. As I've said, it is very important for you to say, move with me to paragraph this of the fact sheet where we see this and this is happening. We don't, some of us have not even read this fact pattern. So when you're saying article this, statute this, we don't know that. Giving full names of the provisions, ICCPR, if you're stating it for the first time, you have to say the International Convention on Civil and Political Rights. You also have to state that the state of Kenya has ratified it. That is when now you can start using it. Many papers. You had 2 books, a paper, a sticky note that was falling. So many things were going on there. It is a lot of confusion. Please, just have one script. If it's a must, you have one book, then you are flipping the pages. But you're having everything. There's nothing that was not there. Yeah. Then this is your co-counsel. Very good teamwork. I saw very good teamwork with you guys. Teamwork earns a lot. It earns people with marks. And when we say turn with me to paragraph, we used to turn even if we're not turning, and then we show. So it shows like there was very good teamwork. You were really helping her, even when she was forgetting which article of the Constitution it is you've opened. That was really nice. You have to be alive to the bench. You and Wamalo were struggling to determine our genders as you were submitting. Yeah, you have to be alive to the bench. When I once answered and said, my lord, and she was a lady, she might be like, okay, it's just a mistake, but it's a mistake they didn't make. You see? Especially Brian never. I think he made the 2 ladies are the ones who did not confuse our genders. It's the little things that matter. Good invitation of questions. I like that she was pausing before she answers a question. Maybe she's thinking, wah, you're swally. But I don't know. I think she's coming up with a very good answer. She has an answer. She's looking for where she has written the answer. You don't have to speak immediately the question has been posed. You can pause and think. And you also need to write the questions, because some of you were forgetting the questions that Nerea has asked. You need to write the question. Okay, she has asked this, because you might be asked many questions at the same time. But there was good invitation. Moving with me to the paragraph. I liked that. Turn with me. Good answers. Very good answers. I believe this is your first time. You had very good answers. Very, very good answers. Practice the answers so that you don't stutter a lot. You should not be struggling to understand what you are saying. Of course, that we lowered ourselves to that point to understand what you're saying. I even asked Blessings, is this what you are saying? No. Pardon. Please. We should not really be straining to get the answer out of you. Good standing on your ground. There was a point mlikuwa mnasumbuana na Nerea, and I would reiterate her statement. When a judge is too harsh to you, because you'll meet very harsh judges, don't fight with them. Combative behavior loses marks. It loses marks. Why? Because she has said she's the judge. You don't fight with me. You are begging me. Yours is to beg. Mine is to judge. So you say, I understand your concern. I take note of your concern, honorable member. No, that's not our submission. But very good. Even if you're taking note of their concern, say, nevertheless, as the respondents, we stand on our argument and our position. So you stood on your argument. That was really nice. There was a very good starting point. I recently dealt with a case on discrimination, and whenever you're saying it's not discrimination, then it is differentiation. That one finished it. When you understand your submission, she just stated the first thing. This is not an issue of discrimination. It is one of differentiation. But you didn't even know the definition of discrimination. And then I just died. Yeah, so kindly know the definitions. Definitions are very important. You need to know what differentiation is, what discrimination is. And overall, I liked it. The rebuttals done by Wamalwa were done nicely. They were in points. They were in 3 points. They were based on what they said and the law. Very good rebuttals. Don't take a lot of time. They were straight to the point. I liked that. Even the rebuttals in the same breath. Didn't take a lot of time because we were already tired. Yeah, that is all I had to say. And the use of electronics, I second that. Yeah.
Hi guys. Let me start by saying this was an amazing session. Personally, I had the best experience I've had so far. And you've made my day. Actually, I was down, but now I'm happy. Yes, thank you. Let me start by a general comment to everyone. Namisi wafichi. You guys do not know your facts. You don't know your facts. Facts zinafaa kuwa hapa. Here. Unaulizwa unajua iko wapi. I should not be the one telling you, but counsel, this is what he said here. No, counsel, I want to, kindly know your facts. And in knowing your facts, it's just not knowing what the facts provides. It's understanding the strengths, the way, by there I could tell how she brought out her facts, the strengths in her facts. And there's also, yes, nimesahau. Okay, I'm sorry. Wait, I will tell you who. Yes, it's knowing the strengths of your facts and the weaknesses that arises from it. Kwanza, the weaknesses. If you cannot identify the weaknesses in your case, then utauma nje, because that is what is going to be used against you. You know, the first thing you do when you get a moot question is you read your facts just to know what exactly the case is about. Then you read again to try to identify what are the challenges, the general challenges that arises from the case. And then you read again, because let's say you've been brought, unafanya issue A, right? Now you try to understand which issues which fact, applies to my issues. You circle them. Now, what are the weaknesses that arise? Na nikisema which are the issues, the facts that are relevant to my case, I mean you identify both the applicant and the respondent, which are the issues that bring out the weaknesses in your case, which are your strong points as the applicant, and which are the strong points as the respondent. That is how you analyze your case. Yeah. Now let's start with Melanie. Vitu mingi imesemwa, so starudia. I personally loved your submissions, and I think you had good research. Yeah, and you also have good response to questions. I think you actually did your research well. And in addressing jurisdiction, I think you didn't refer to any facts in your case. I didn't hear any facts. These are matters of interpretation and application of constitutional provisions. So you had to show us which are the provisions in the Constitution that are being interpreted for you to invoke the jurisdiction of this court, which is, and is it Article 163(4) A and B, right? So you have to show us that yes, this jurisdiction draws its power from Article 163, and I think you should start by saying that, because what law or what statute provides for the jurisdiction of this court? So before you make your submissions, just let us understand where you're coming from. Sawa? Yeah. Wamalwa. Yeah, yangu ilikuwa fillers. Reduce on fillers. It can make a person think that you're not sure of your submissions. Now, for the applicants generally, kindly avoid the use of I, in my opinion. No, that is why I was saying this is not a court of opinion, it's a court of law. So don't use the word I in your submissions or in my opinion. Court demeanor, kindly come with a blazer next time. All of you who didn't come with a blazer, thou shall come with a blazer. Or else will tell you, cancel, you're naked, we cannot see you. How can we hear you? Okay, all of us are going to come in good suits next time, including the participants. And us too, yes. What else? You're addressing the issue on, wait, which issue? No, Wamalwa. Yes. Public participation. Look into case laws. Sawa. And then I want you to be able to bring out, you're saying you're only relying on paragraph 19, which I think is a bit, just go back to your facts. And then you marry your facts, to your case to your facts. Yeah. Allow me to address the rebuttal. I was really having a good time until you mentioned your professor. I think that broke me. Okay. So Charlene, the issue you're handling is very technical. That is matters to do with the right to privacy. So reliance on your opinion is inaonyesha you didn't do research. So you have to have a lot of case laws. Kwanza kuna a lot of case laws on the right to privacy. A lot. In fact, kuna yenye naleta, I think there are facts. The facts of that case and the facts of the present case are very similar. Very similar. And the holding could be even in your favor. Just go look for that case. I am so sure Iko. Yes. Iko, by the way, Iko. Say it in English. Yeah, I'm very sure. Iko. So go look into it. If you don't know whether the right is absolute or not, just achana nayo. Just seek guidance from the bench. Look into the data protection principles. I think it will be your best points of reference, especially data minimization. Yeah, go look into GDPR, the principles of data protection. You'll get a lot of points from that, Nini. That will make your submissions better. When giving specific prayers, which I think is the best way to give your prayers, be sure of the specific prayer you're asking for. Kama ni unajua order of mandamus ni ya judicial review, and the present case that we have is on, is it constitutional? It's a constitutional petition, right? Yeah, so order of mandamus does not apply. Inaweza kufanya umenje sana. So when you're giving specific, I think hata iko kwa constitution, so just go analyze the specific prayer that you can ask from the court. Sawa? Brian. Now you have, okay, for all of you, by the way, you guys work on your court demeanor. Yes. But I think you guys were good. For the first time, I think I'm listening to you guys for the first time. I don't know if you have ever mooted, but I can tell that you did a good job. Haya. On what grounds are you relying on international cases, the cases within the Kenyan jurisdiction, the cases within the African court jurisdiction and all? zote mnafaa kutuambia on what, ndo nisishinde nikiwauliza on what grounds are you relying on cases. Sawa, it is persuasive. All cases before the Supreme Court are persuasive. Sawa, even the cases that were decided by the Supreme Court itself, they are persuasive. Yes, do not ask the bench whether they've understood. Have you understood? You kept saying that a lot. That like in invite more questions from the bench. You just go ahead with your submissions. If they're not satisfied, they will ask you questions. Sawa. You want speaker to speak? Yeah, identify the weaknesses in your case. It's very important. Ndo ukiambiwa abandon an argument simply because it's not there within the facts, then you'll be ready with any other submission. Sawa. Now to the other team. But generally, that was a good start. Blessing. Work on your composure. That is my very first argument. My first comment, work on your composure. Number 2 was the story of scripts. Come up with a script. 1 paper is enough, even 1 page. There are times when you answered questions, you're keeping quiet for. You just remain silent for a period of time. You're waiting for the bench to tell you to continue. No, once you have given your answer, just mark your submission. And I have a problem with, I don't know. I think it was Brian. You were asked a question and then, no, when you are asked a question, generally, when you're asked a question, just use that question to advance your argument. So, or you go just specifically to where that answer is. Don't push bench into your next submission. Just or unasema, this now leads me to my second line of argument, which is the position of the applicant or have clarity of your issue, of your case, or have clarity. I was struggling to understand your first issue. Your presentation or your submissions inafaa kuwa with a flow of thoughts to the point that if the bench has not read the facts, wanafaa kuwa able to understand, okay, so this is where she's coming from, this is where she's going. Yeah, you get? So have clarity of your case. Good analysis of case laws. Have a script. That was my major issue. For Whitney, the 2 of you had good introduction, by the way. You know your facts, good knowledge of the case. Whatever they are saying, no, when you're responding now to, I noted that. Whatever they are saying, no. Unaweza sema, the claimant, the applicant stated this and this and this, but it is the position of the respondent that this is, no, not whatever they are saying, just remember. Great teamwork, good composure, good response to questions. Yeah, that's all from me. Any clarifications?
Before we conclude, we can have one of our very good dear friends. He recently participated in the JESUP competition, and he can just give you guys some general guidelines. Yeah. So I have made him wear a robe just because he's a senior. So I think he can take us through. Yes.
Good afternoon. So first, from the comments from the judges, I guess I missed a very amazing session from you guys. So I participated in the JESUP moot competition last week. You were at Strathmore and you made it to the second runners-up. It was a very amazing experience. Having mooted again from 2021, I assume this is your first moot, right? Let me give you a story. In 2021, you were admitted to law school, and I registered for the SCJ moot court. But now we were like 3 first years going against around 8 third years and 4th years. Those guys mopped the floor with us there, bana walitunyorosha. But I made it to number 7, which I was happy either way. But from that day, the experience was amazing, but I asked myself, now what is this? So I left mooting. Last year, I was just talking to my brother and he asked me a question. Like, if you were to go back to first year, what one thing would you change? Of course, sikumjibu because I was like, bro, nini hizi umeanza tena? But one thing that came to my mind, if I was to go back to first year, I guess I'd register for more moot courts and participate in those things. Because moot court will open for you opportunities. You can go now for like the Kenya, Murira, I guess Murira, he usually work at Rachia. He got connections from all Kenya moot court. If you know Vincent Kenya Law, Shamaya, Sharia, kituo cha sheria. One of our alumni, Abraham Wakiaga, he was sponsored to, also the likes of Kinanyanje, Faith, Mr. Ayub. I don't know if you met Mr. Ayub. It was because of moot court. He got a scholarship to go to the US to do his master's there. So now, from my comments, I don't have much to say, but one thing I can tell you, from the JSAP, Wakega called us and he told us, you guys had very good submissions, but what you're lacking, it's how you say it. Moot court, it's not about how much you know. Of course, you are a student, you can't know everything in law, but how you say it is not what now sets the difference between you and who wins the moot court. So work on how you say your submissions, put emphasis, base your arguments, make sure whatever you are saying, the bench can hear you and understand you. And start with the strongest arguments. You can even have like 2 or 3 limbs of arguments.